Donna Adelson's fight for freedom isn't just over yet. Or is it? Just 10 days after her guilty verdict, her lawyers, Jackie Fulford and Josh Selman, are now demanding she gets a new trial. And get this, they actually cited Surviving the Survivor in their filing. Tonight, we break down what it all means.
Welcome to the global phenomenon, Surviving the Survivor. Here's your host, Emmy award-winning journalist, Joel Waldman.
What's up, STS Nation? Welcome to Surviving the Survivor, the show that brings you the very best guests in all of true crime. Tonight, Donna Adelson's legal team is asking the Leon County judge, Judge Stephen Everett, to be precise, to throw out her conviction and grant her a brand new trial. Their motion claims juror misconduct, prejudice in the courtroom, and even judicial bias. And at the center of it all, one of the jurors' appearance right here on Surviving the Survivor. We're digging into what's real, what strategy, and what chance Donna has of winning this high-stakes legal gamble. Or is it a low-stakes legal gamble? Here to break it all down, the letter R, O-U-R, Timothy Jansen, the famed Tallahassee criminal defense attorney and former federal prosecutor. Then you've got the high priestess of STS, Professor Emerita, University of Nebraska School of Law, Joe Potuto, and Betsy Burgess, the woman who Jared Ross claims is smarter than he is, which is why he said, have her on the show. Don't have me on here. Oh, there you go. Agreed. There we go. So in the affirmative. Thank you all for being here. And I got to tell you, it was not how I was expecting the afternoon to unfold. Tim Jansen with Surviving the Survivor in a court filing. First, it's the interview of Dan Rashbaum. Now this. Is this all much ado about nothing, Timothy Jansen?
You like baseball?
I do like baseball.
This is like the manager coming out when they get the bad call strike. He comes out and kicks dirt, shakes his hand, puts his chest up, and then he goes back to his dugout. That's what this is all about.
There you go. Joe Potuto, we got you the filing. By the way, Joe's gone limited time just tonight, not in life, but just tonight. She's got to be somewhere at 7:45.
Unfortunately, I think we all have limited time in life.
I think you're right about that. Joe Potuto, what was your initial reaction to reading this filing today?
With particular attention to the challenge to the two jurors, I thought about it a little. You know, this is cherry picking, finding two cherries in a huge orchard of cherry trees. There's nothing here that I can see, at least from what they've alleged, nothing.
Yeah. Toronto's in the house, important because, of course, Dan Markel is from there. Betsy, I was in the courtroom when the guilty verdict was read. Donna Adelson had zero remorse for Dan Markel and felt awfully sorry for herself. She was, I think, in denial. Is this part of the denial that she's just not going to be able to accept a conviction here? And is this the last we're going to hear from her attorneys, or is this going to go round and around and around?
You know, these motions are filed in every case. Pretty much every case. Charlie Adelson filed one. Remember, I don't know if y'all remember, but the group chat that was alleged to have been created amongst the jurors in his trial, he filed a motion about that. It was denied. So I think I wasn't surprised at all. I knew this would happen. What they're doing is just setting up additional appeals, because every adverse ruling they get from the judge, they can potentially make into an appeal. So they're doing what they have to do. But Donna is just one of those people, she can't accept defeat. You know, if she's defeated, then there has to be another reason, right? Like, it was rigged. I didn't get a fair trial. And you hear this over and over in the jail calls. And so, you know, this was fully expected. I don't personally think the motion has a lot of merit. I think they're making some allegations that are not borne out by the actual interviews that these two jurors did. And when this first happened and these jurors started coming out, it gave me a little bit of heartburn, because I was like, oh no, I hope they don't say anything that suggests that something happened, you know, in the juror room that was going to compromise the verdict. And I don't think they did. I think, they were very honest, and they were allowed to talk. They're allowed to talk after the jury, their jury service is over. So, I mean, they're doing what they have to do, just like they have this whole trial, but I don't think it's going to be successful ultimately.
And Jared Ross, a man who says his intelligence is inferior to yours, is commenting nevertheless, saying, I don't think this is denial. I think it's pretty standard for a convicted defendant to try and put more on the record, which is essentially what Betsy was just saying. Nothing more. I got to tell you, we were on a group chat, and I was asking Betsy and Jared if I'm going to be carted away to jail, to Leon County Jail, and they told me to rest assured that would not happen. But Tim Jansen, I should have called you Tim Jansen, but
yeah, really, you call him Betsy and Jared?
Yeah.
What were you thinking?
Tim, let me ask you.
Give me my bondsman's number.
Yeah, exactly. This is like your wheelhouse, Tim. So, just in your own experience, for clients of yours who do get convicted, and there are few, because you work out deals and your magic, Tim. But for clients that I don't know, do you find this at times that clients, Jared saying it's not denial, but are they, for lack of a better phrase, up your what after a conviction to say, you got to get me out of here, you got to pull whatever ace you can out of your sleeve? Is that what Don is doing here? Just do whatever you can, file whatever motion you can.
Well, they have to have a reasonable basis to file motions. There has to be a basis for it. You can't just file fraudulent motions. I can see them trying to file these motions for a new trial. They pick some areas that maybe there's something they can find, get the judge to allow them to interview them and see if there's anything more. The court could do an independent hearing on their own in camera of these jurors. But listen, these jurors came out. It's different. It's a different generation from Joe and I, and Betsy's probably a little younger, but we never used to see jurors come out and go on social media. I mean, a lot of times jurors really didn't go out at all, or they would only speak in private. But now they come out social media, they talk about it, they say what they did. And everything I heard from the foreperson gives me great confidence in the jury system. It sounds like she did exactly what the instructions were. Mm-hmm. Every procedural thing that she did was spot on. And so I don't think there's any error here. The fact she put on TikTok, I am on the jury, I don't think that's going to amount to anything that affected the verdict or her decision.
Yeah, and there's context there. If you go back on the video tab, you can watch the interview we did. She has an ill 1-year-old child who's born with a heart defect. And so she posted on TikTok saying that her prayer was answered, and she was essentially looking for a distraction from this tragedy that she's dealing with. It's right there. When I told God I needed a break, and he makes it so I'm selected to serve on a jury for what amounted to almost a 3-week trial. That's what she's talking about. Joe Potuto, I mean, this seems pretty benign. It's not like I'm sitting on such and such trial. She didn't name what it was. She didn't say she had a feeling about it. TikTok is a big part of 26-year-old people's lives these days. I mean, it seems benign. What do you think?
I agree. And the instruction was, do not communicate about the case. I do not believe saying I'm on the jury is communicating about the case. The instruction goes to any substantive information, talking about it with people who are not on the jury. So I don't think it's a violation of even technically is in conflict with what the judge said. And as I recall her interview, she talked about not talking about anything on the case, but the judge didn't tell her she couldn't go on TikTok. And I thought she and the juror who was on STS and the third juror that you interviewed, Joel, were all extraordinarily thoughtful and described their service in exactly the way a defendant in a criminal case would want her jury to act and to comport themselves. So I don't see that there's anything there.
Yeah. And Betsy, if anything, from Sienna Tittle Sleuths here, I like the name. The juror specifically said, we interviewed 3 jurors, 5, 6, and 7. So it's kind of hard to forget. 7 is the foreperson, 6 is a 25-year-old young man, and 5 with so-called Sprinkler Man. All of them, to me, in every interview we did, and you can go back and watch the tape. And in a minute, we're going to go through this filing. The COE was able to highlight the filing, and we're actually going to go through it. But by all accounts, and I was the one who interviewed them, I don't recall talking to more thoughtful jurors. I mean, they really seemed like they took this as seriously as possible, reserving, the deliberation room for deliberating, not really giving it forethought in terms of innocence or guilt. And it just seemed like they were on the ball to me.
What I noticed in the motion is the part of it that references surviving the survivor. They're talking about juror number 5. And I remember that interview, and they're referencing the time he referenced that he was looking at Donna during certain parts of the trial. Well, the jury's allowed to look at the defendant. I mean, but he very specifically said that didn't sway his opinion one way or another. So, I feel like that none of these juror related allegations are actually supported by, if you will, the record in this case. And especially if that's all she posted. I was going to ask, because I didn't know what the jury 4 person had posted during the trial. But if all she said was, I get a break, I'm on a jury, that's nothing substantiating like what trial she's in. She could have been in federal court. She could have been in state court. This could have been a civil case. It could have been a criminal case. There's none of that information there. So, jurors aren't expected to completely abandon their lives when they serve on a jury. So I think this is just, it's a reach, but they're doing what, they can do with the facts that they have.
Yeah. As a matter of fact, the COE pulled up Judge Everett and jury instructions. We're not going to listen to the whole thing, but COE, why don't you pull up a part of it? Before you do that, Joe, look at this. I keep getting this comment over and over. Can you help the professor get her own YouTube channel? I can't force her to do anything, but we'll discuss it. And everyone loves the professor. Tim Jansen and Joe, we're talking about doing something together. We'll see if we can twist their arms. But COE, let's play these jury instructions. This is the great Judge Stephen Everett here with a complete command of the I shouldn't say control room. That's a TV. Complete command of the courtroom.
All that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, please notify my courtroom personnel concerning the violation. During the course of the trial, the court may take recesses or breaks, and you will be permitted to separate and go about your affairs, or you'll be returned to the jury room. During these recesses or breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about this case. If anyone attempts to say anything to you or in your presence about this case, please tell him or her that you are on the jury that is trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to my bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you're in the courtroom. Turned off means that the phone or electronic device is actually off and not in a silent or vibrating mode.
All right. This goes on for 4 minutes. So I don't think I'm going to torture you with that. But Tim Jansen, I mean, the judge is as clear as can be. He goes on, every angle of the jury instruction that you can think of is mentioned here. We could listen to another minute or so, but again, nothing, I assume, jumps out at you as an infraction from any of these 3 jurors that did interviews, at least with us. And by the way, they've done interviews with a lot of other people too.
Yeah, you're covering yourself there. And I wasn't part of that show, so don't blame me for that. No,
You were out.
listen,
You're partying in Nantucket.
I was hosting friends up in New England, and it was a long trip. I planned trip, so listen, we would recognize jury misconduct when we see it. I called my friend. My friend said he's guilty. My friend said, listen for this. Anything like that that would bring in a third, something outside the jury for them to consider. Anybody talking to them discussing the case amongst themselves before the case is given to them. Anything that showed that they did anything other than listen to the evidence and do a verdict. There's nothing here. I understand why they filed it. They have to file it. Motion for a new trial, insufficient evidence. Yeah, that lost already. And then they get this jury people. They were listening to these shows and they found something, they can file something. And Donna said, please file it. If you don't file, it could be ineffective counsel. If you got any rational, reasonable basis to file it, they're going to file it. We've seen their motion practice, Joe. We've seen what they file. It's not, most of them did not have a good chance of winning, and they didn't. They had one that we all agreed they should win, and they won. So I don't think it's much to do about anything, really.
Yeah. And Betsy, now just walk us through the process here. Now, does the state need to respond to this, or is this simply going to be responded to at some point soon by Judge Ever? And how soon would that be?
Well, there would typically be a response and then a ruling. So there could be a hearing on it, but the court could also, Tim, correct me if I'm wrong, because I primarily practice in civil court, but
Right.
the court can generally rule on the papers.
They
if
can.
They feel, if they feel that it's warranted.
If you see you see a lot of these motions, Betsy, the government never responds. The state never responds. They usually wait to go to court and they respond orally. That's how much they think about these. Unless the judge directs them to give a response, then the judge wants something in writing. But I don't think they're going to respond.
So, Tim, what does Georgia do when she reads this morning or this afternoon? She just shake her head and go, whatever?
She probably go get a cup of coffee and said, can you believe another one of these motions? Sarah, you want to do it? Let's flip a coin who's going to respond to it.
I would have said
I'm being
stop.
facetious, but it's getting to that point that they know this is going nowhere.
Yeah, we're about to go through this. Dom's mom with a question for the professor. For any of the best guests, this is a percentage of appeals, has professor written all over it. Joe, what percentage of appeals are actually granted? Seems like appeals are rarely granted, Joe. I'm sure.
Well, if you mean, in a criminal case from the trial court to the appellate court has to take it. If you mean how many are successful, not very many. Because typically the judge does an adequate job at trial. Defendants are entitled to a fair trial, not a perfect trial. And it's really not frequent that there's an error at trial of such magnitude that it requires a reversal of a conviction.
There you go. All right, so let's start looking at this. This was filed just today. Again, it's a motion for a new trial and for leave to interview jurors. Let me just hold it right there. Tim Jansen, how common or uncommon is it to literally ask for your convicted killer to be released to go conduct jury interviews with their attorneys? She wants a field trip already.
Yeah, that is not going to happen. I can tell you that. And the jurors are not going to McCulloch County Jail and let Donna make faces at them when she doesn't like their responses. That's not going to happen.
By the way, I'm most concerned that Jackie Fulford is watching this and knows that we call her Tom Petty. So maybe that was just in jest, Jackie Fulford. But okay, so Donna is respectfully requesting that the court grant a new trial. A jury convicted Mrs. Adelson as charged in the indictment on September 4, 2025. The motion is timely. File within 10 days of the rendition of the verdict. Miss Adelson requests to leave to interview juror 5 and juror number 7.
Yeah, Joe, I think that just means the defense wants to
Right.
interview. I
Yeah,
don't
it's
think
not
that
Donna.
means that
It's
she's
the
going to leave
defense.
the jail to do the interviews herself.
Yeah,
That would be
it's the
bizarre.
defense. It's the defense.
You imagine Donna gets out and now she's hosting a podcast. So Miss Adelson files this motion for a new trial on the following grounds. Here are the 3 points that they're bringing up: juror misconduct, verdict contrary to the law or weight of the evidence. The court erred in a decision of any matter of law which arose during the trial, and for other cause due to Mrs. Adelson's fault, she did not receive a fair and impartial trial. I mean, Betsy, which of these, if anything, hold possible weight? See, let's go back up there for 1 sec. I'm sorry. Which of these 4 hold any potential, or 3, I guess, hold any? No, there's 4 potential weight. The jurors, juror misconduct, verdict contrary to the law. I don't even know what that means. The court erred in a decision. She did not receive a fair and impartial trial. It sounds like a lot, as my dad would say, sounds like a lot of hot air.
Yeah, I don't think any of them hold water. What they're asking the judge to do is say, I made all of these mistakes. I allowed people to giggle and laugh in the gallery. He didn't. He admonished them every time it was brought up. He warned them over and over again. He was very clear. I can't kick everybody out. It's a public trial, and what they're asking him to do, that's the most problematic, is substitute his own judgment for that of the jury, which is a very extreme thing for a judge to do, and goes against the entire policy in this country of jury trials. That when the jury speaks, their decision has to be respected, unless something very serious has happened that implicates somebody's rights. And I don't see that happened here. It's interesting to me they don't even mention juror number 6.
Yeah.
Because I know he gave quite a few interviews, but I just don't think any of them have hold water. It's basically the same arguments they made during the trial, and those motions were denied towards the end of the prosecution's case. So I just don't think they do.
And I think in a little bit, the COE will play juror number 5, so-called sprinkler man, because he said over and over, when we get to that, he said that, he really reserved all critical thinking, I think, for the deliberations room. Like, he was taking notes, but he hadn't come to a decision. Tennis Girl 101 here. Go ahead, Joe.
Yeah, I was going to say the jurors' misconduct, I think, is a no-go completely. The second claim, which was technically there was enough for proof beyond a reasonable doubt, but you should need more than that. Again, it's going to be a no-go. The 2 that I think the state is going to end up, whether in response to this motion or certainly on appeal, that they're going to have to deal with, are the judge pushing Donna to say she didn't want to testify rather than give her more time. I also think that one will not be successful because he gave her a lot of time before, and what they say they needed to talk to her about in order for her to make an informed decision didn't really persuade me. The other one, I think, is the most substantive of the 4, and that is the claim that for murder 1, she did not do something that put her within the ambit of murder 1. I think that one, again, will not succeed. And what I didn't like about the way they briefed 3 and 4, and what Tim and I have been saying all along with their motions, is their motions speak in generalities. They never point to anything. Now, maybe they didn't have enough time to find transcript sites when they did this motion. I'll give them that. But they overstate the record clearly. And at times, their version of what the testimony was doesn't comport with what I recall the testimony to be, which is just bad lawyering when you do that. But the claim on murder 1, where the claim is that she didn't do anything, and they cite from a case that Tim had some involvement with.
Some involvement, yeah.
Yeah, they say
just a little bit involvement.
Yeah, they say that Williams, the Denise Williams, in that case, the court said, and it's accurate, that to be a principal for murder 1, that is to be convicted of murder 1, the acts have to be before the conviction, before the crime. But that's not a case in which it's murder for hire. I mean, in murder for hire, you agree, but I mean, I don't have a lot of familiarity with what people do, but it seems to me in at least some of the cases you get paid after, not before. And so they're quoting, I think, accurately from the case, but they're pulling it to a place where it shouldn't be. So that's the one, though, of the four, I think the state on appeal will spend the most time with.
So, Joel, number three is a catch-all.
Mm-hmm.
And the appellate lawyer probably told him, listen, if you don't ask for a new trial, you've waived it. So just say anything that the court ruled against you. It's a catch-all. Anything that was contrary to the law, we're putting it in here so we can get a new trial. I don't think that's going anywhere. I agree with Joe. I think the first-degree murder is the only real appellate issue on the case, whether they had sufficient evidence before the murder that she took any action before the murder. That's probably one of the reasons why she didn't testify, because they saw that Denise did not testify. And if she would have testified, the insufficiency of the evidence, that appellate issue would go away. And so would, and the first degree murder conviction would have sustained, because a credibility of a defendant is sufficient enough to get a first degree murder. If you get up there and lie, they don't find you credible, you lose your insufficiency of the evidence.
Spoken like a true
and like Joel said, when
Yeah.
Joe said the thing about her not testifying, I was concerned, but you know what? She had 24 hours to change her mind and come in, and Georgia was ready. And I think if she would have came in the next day and said, I want to testify, the judge would have let her.
Yeah.
I do
Yeah.
too.
I mean, Georgia was preparing for it, so that sort of implies that she was expecting it, right?
Right.
Penny Green, thank you for the super chat there. Jimmy McNutty says number 5 is Mitch McKenzie, aka Sprinkler Man. 6 is Evan Higginbotham, a student, and 7, JC Maxon Walker, a foreman, mother of 2. Please go to our video tab, and if you can, just watch it for the first few minutes. It explains. We have a GoFundMe link in there and explains what is going on with a jury 4-person's 1-year-old son, Josiah, was born with a defective heart. And that's the most important in this whole story here today, is to try to help Josiah. McSpunky, as always, Mr. McGenerous, gifting 10 YouTube memberships. I was going to ask Tim, but let's keep going down here. And let me ask Betsy. There was a question posed. Do any of these jurors, Betsy, need to hire an attorney? I don't think
Absolutely.
so.
Absolutely.
Tim Jansen. And his name is R. Timothy Jansen. Yeah.
I mean, I watch Dateline, and so I would say I don't go to any kind of interview without a lawyer. I mean, I'd call Tim and say, look, just come with me to this thing.
Don't worry, guys. Tim is going to do a pro bono.
Very good. Oh, for Betsy, I'll do it pro bono.
Yeah. For the jurors to do
But
it pro
Joe,
bono.
I do it pro
Thanks,
bono for
Tim.
you too, Joe.
Yeah. All right. So we're on to the meat of the motion here. Juror number 7, that is a jury 4-person, JC. She went, this is now the motion. These are the words of the defense attorneys. Juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial, which is not true. At the beginning, she just said, I'm part of a trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. So Tim Jansen, again, I mean, Joe said she doesn't think it's much of anything. It's a 26-year-old woman, a mother of 2, who's dealing with a serious health issue with one of her children, and goes on to TikTok simply to say, you know, God must be working in my favor. I needed this distraction, and I was chosen for a jury. That seems pretty benign to me.
They got as detailed as they could get, and they couldn't put anything in there that's a smoking gun, nothing that says it affected her decision or that she brought in anything outside that influenced her decision. So it's nothing. It's no harm, no foul.
Yeah, agreed. So let's move on to the part that gave me a bit of a heart attack today. Number 8 here. Juror number 5 appeared on the podcast Surviving the Survivor. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. Although he subsequently stated he obviously did not consider that during deliberations. I mean, Joe, they're making an argument and then defeating their own argument, aren't they?
Yeah, and I don't think that's a correct characterization, even of what he said about looking at her during the trial. They characterize it as that he considered how she reacted to the evidence and testimony. I don't think that's what he said. He said he looked at her, but I don't think he said he was wondering how she would react and did it for that purpose. And so I don't even believe the first part of it, although they gave us a footnote, and I should look at the footnote here. And then it isn't that he subsequently said, that sounds as though, a long way down the interview, he then said, gee, and I didn't consider it. He said it right at the same time. And Joel, I was in that interview with you. I'm not getting a heart attack over it, so you should be calm too.
You know what? I completely forgot about
that.
I
was there. Now. No problem.
Oh, so all those should be coincidentally.
Yes.
Right? I feel much better. COE, let's play that sound. This is juror number 5, Mitch McKenzie, who is a Marine, by the way, served tours of duty in Iraq and Afghanistan, and then served on this jury. Let's play that sound. We have 2 pieces. We'll play one of them now.
Bob was on the stand when they brought Wendy in. There were certain witnesses that when they brought in, I was focused kind of on her reaction and body language. I really just wanted to see how she reacted to certain things. I know a lot of people don't really want to pay attention to her. They want to pay attention to the witness. I wanted to see how she reacted to the information that was coming out. Not that I could use that against her during deliberations, but it kind of gave me a sense of.
Hold that right. I mean, Betsy, he literally just said, I'm a juror. I'm sitting there. I wanted to see her reactions. And he says right there, I didn't hold it against her in deliberations. I mean, isn't it a completely moot point? I mean, any juror is going to look at react. You can't, I mean, that's like, trying to control someone's behavior. Jurors are people, right?
So they're not required to check their humanity at the door when they enter for jury service. I mean, it's a completely natural thing to want to, when you hear something, you just to look and see how somebody reacts to that. But then he very clearly says, I wouldn't have held that against her, and I didn't. So, I mean, it's asking too much of jurors to just completely ignore this person that's on trial for murder, whose future is in their hands, and never look at her and never observe her.
And let me add that if the defense didn't expect jurors to look at a defendant, they wouldn't put her in cardigans. They wouldn't have her hair down. They wouldn't make her look like a grandmother. They wouldn't have her, and she wouldn't be crying with no tears at times. Right. I mean, all that is done for purpose of having an impact on the jury. I mean, it's just, it's crazy to say that doesn't happen. And it's even crazier to say that if it happens, there must be reversible error in terms of the trial.
They would have missed her fake crying when they showed Professor Markel's autopsy.
Yeah. I mean, Tim, what is, by the way, Joel, you have the best guess. It's not just a tagline. It is our reality. We have the best guess in true crime. I've been saying it since we started. It is the truth. You'll not find a better panel anywhere. I will give you your money back if you do. Tim Jansen, what does Judge Stephen Everett do when he gets this? I mean, take me behind, into his chair. Does he just roll his eyes and goes, oh man, I can't believe I have to respond to this now?
Well, he might go buy some more snacks and then think about what he's gonna do. He's seen this before. He's a seasoned judge. He never loses composure. He sees what it is. He'll have his clerk looking at the basis and what the law is, and maybe he'll set a hearing and then have a hearing. He's not going to do anything with the jurors at this point, because I don't think facially he could deny it on its face. Say denied. You haven't met the legal standard for a new trial. You haven't met the standard to interview jurors. Motion denied. Maybe he'll put with prejudice on it. But I don't think he's going to really consider it that much. He'll consider it. He's got to consider it's a motion filed, but I don't think it's going to warrant a full hearing and witnesses being called.
I'd actually love to follow a judge around for like a week and see like what they do when they're not in trial. I think that would actually be sort of fascinating. Besides go to the Metro Deli, I'd like to see that. All right, I love this dude. This is Mitch McKenzie, a Marine, very thoughtful juror. Let's keep playing this COE and see what else he has to say.
Want to pay attention to her. They want to pay attention to the witness. I wanted to see how she reacted to the information that was coming out. Not that I could use that against her during deliberations, but it kind of gave me a sense of where her head was at, I think, during certain testimony.
But what's your biggest takeaway from the nearly 3 weeks of service that you just gave as a juror?
Honestly, the gravity of what was going on around us. I mean, like I said, I knew nothing of this case. So as the information going in, I think it was downstairs day one where they come in and they tell us the case that they think it's going to be, kind of as they're vetting us to find out if we're going to make it upstairs. I didn't know what the case was. So as the information was coming out, just again, the gravity of it, and to see how many people this crime affected, the innocence that was lost because of this tragedy.
That's Mitch McKenzie, part one there on our show last week. I mean, Betsy, seriously, I don't think you can ask for a better juror. I mean, it's a guy who, as I said, served his nation. He even talked about how he's divorced, but his best friend is his ex-wife. I mean, how many people could say that? A complete, 180 from Wendy Adelson. And he just came out and said he was kind of looking at everything, which is what I would expect actually from a Marine, the way they're trained, the way they're conditioned. He was looking at everything and reserved his deliberations for the deliberations room. I mean, this is almost an embarrassing, like, waving of an SOS flag by the defense here.
Yeah, I mean, what I heard him say just now is he didn't hold that against her. He was listening to the judge's instructions. He understood, that to the extent he looked at her and he observed her reactions, that wasn't something for him to take into the deliberation room and use against her. So, my dad was a Marine. He flew fighter jets in Vietnam, and he, being raised by a Marine, I truly respect them and him as well, and thank him for his service. But I don't hear anything along the lines of any kind of external impressions that may have been made on him, things that would be relevant to this legal analysis. I just don't hear it. And so I just feel this is grasping at straws. I agree with Joe and Tim about that.
Betsy, I knew you had badass in you. I just didn't know that it came from your dad. Look at that.
Yeah, you should know. You should get to know my mom too. She's a real badass.
She's not a Marine, is she?
No, she's had 6 kids, and she might as well be.
Say no more. Say no more. Love STS wall-to-wall coverage of this crime family. Can't get enough. There might be more coming. Time will tell. The jurors did not know whether Jackie or Donna was the attorney. That is true. They did not know whether Donna or Jackie was the attorney or the defendant. It took a couple of days for some of them. So that that probably tells you, Jackie, that she might, I can't say because now I know she watches, but maybe get a little bit more fitted suit next time. Number 15 here. A motion for a new trial. Remind me not to go to the gym right before the show. It's bad for me. A motion for new trial requires a trial court to evaluate whether a jury's verdict is contrary to the weight of the evidence and to act in effect. As Joe Potuto, in your remaining minutes, please explain this. This is the kind of sentence I would have to read 47 times in your class. It's wordy and it's lawyerly, but explain what this all means here.
Yeah, essentially what they're arguing is that even if the jury technically could find that Donna was guilty beyond a reasonable doubt, that it's in the discretion of the judge to say, yeah, technically true, but there's just not enough, that the weight of the evidence still looks like it would not be in the interest of justice to have her be convicted. And it's a very odd motion because you would think a jury verdict should be sufficient. It's rarely granted. And it's even more rarely granted on a motion now as compared to making the same claim on appeal.
And Joe, let me ask you a question, just a follow up. Yeah, I know we're gonna get to that. To Mitch McKenzie in just a moment, but Joe, your number 5's statement, about looking at Donna, they talk about extrinsic evidence. What does that mean in English?
Evidence is an odd way to put it. It means you're looking at something that's not on the record to be considered at the trial. So the witnesses, the exhibits, even the demonstrative exhibits, those are all part of the record at the trial. How somebody sitting at counsel table looks, or whether that person frowns or not, or anything that's happening outside the four corners of the trial is extrinsic.
By the way, both Jackie Fulford and Josh Zellman have an open invite on my show anytime. I would love to interview them. It'd be very interesting. And if they're watching, you guys are both invited. Let's play that next soundbite. This is the second soundbite from Marine Mitch McKenzie, otherwise known as Juror number 5, otherwise known as Sprinkler Man.
I showed up day one, the Friday.
Sorry,
No. Oh, Joe's out of here. She disappears quickly. Okay, here's Sprinkler Man.
Irish goodbye.
An Irish goodbye. Yes.
I showed up day one, the Friday, day one of the actual trial. I show up almost an hour early before we're told to be there, and I'm the third person there. So I know it's going to be a great jury. And I mean, everybody was there at least 15 minutes before we were supposed to be. So just professional, locked in. We were given instructions not to talk amongst ourselves until it was time to deliberate. You could tell that there were some folks that were really wanting to talk. I wanted to talk to them about it, but everybody was so professional. And that may have been the biggest surprise for me coming out of the jury room itself. So we voted each point under each charge verbally. And if everybody wasn't a solid yes, and it wasn't even, again, this jury was so good and so professional and so locked in on what we were there to do. If anyone even, count one, bullet point one, if it's yes, yes, if there was the slightest hesitation, we stopped.
Hold it, Dave.
What that hesitation was caused from, and we went back, and everybody at the end of the day was a solid. I mean, once we got to the final decision,
we paused the COE
before we wrapped up.
I mean, he's literally saying there, Betsy, if there was even the slightest hesitation, even in the tone of one of the jurors' voices regarding one of the counts, they went back and rehashed it. I mean, all you have to do is, they're citing Surviving the Survivor, but all you have to do is play this interview from Surviving the Survivor to show how seriously they took their jobs, right?
Right. The interview is exonerating.
Yeah.
Listen, what he said that, that's a Marine, and that just speaks to the overall quality of the jury. I mean, early is on time is late, and late is unacceptable. And they were there an hour early, and everybody was raring to go. And then they had the respect for each other to say, look, if you don't agree, if there's anything you don't agree with, let's talk it through. They weren't in any kind of rush to get this done. And that's exactly what you want in a jury. So I still am not hearing anything that could give rise to a credible allegation of juror misconduct.
The worst part of this, Joel, is why the defense would keep this man on the jury. He's a lawman.
Yeah.
Believes in law and order. He's a Marine, and he's got lots of common sense. What did they not have in their case? Any common sense. And I would have never kept him on my jury as a defense lawyer. I love him as a person and service. I wouldn't want him on my jury.
And that's an amazing point. I mean, Tim, you come across him, you're literally, he's one of your first strikes, I bet, right?
Oh, absolutely.
Yeah. it's crazy. All right.
Marines they do their duty. They're going to follow. They don't like BS. They can see BS right away. That's why he was looking. He was looking at the defense team too, I'm sure, and thought, oh boy, there's nothing going on over here. So, I mean, it's just, you would never keep, I'd like to know what they were thinking when they kept him on that jury.
Tim, you're looking very you're looking very dapper today, Tim. And Betsy, I must throw a compliment. I like your glasses.
Court TV interview this morning.
Of course, that's why he's looking dapper. Of course, for Court TV, he gets all dapper.
I'm doing your
Tim Jansen.
He's hot mess history. The Adelsons are the real life but evil version of the Mandelbaums from Seinfeld. They just can't stand to lose. There you go. COE, let's play out. Your show is going to be her evidence that proves her wrong. Let's see if that happens. But COE, let's keep playing out the Marine juror number 5, Mitch McKenzie.
Once we got to the final decision, before we wrapped up and did anything official, we went around the room again to say, hey, now is the time. If there are any concerns, any questions, any doubts, let's address them. We talked about, hey, this decision, regardless that we're all at a guilty verdict in our head, and we verbalized it at that point. This is still a lady that deserves as much fairness and as much attention to detail as we can give her, because once we make this decision final, that is her life. She's going to prison for the rest of her life.
Right there.
So there was a lot of weight in that room. I mean, everybody sensed that. You could, the folks that like to sit around and kind of, not make light of what was going on, but just to kind of keep the room light at times so we didn't all, go crazy in there. You could see the seriousness of this decision on their face. So absolutely, it was heavy in that room.
I mean, again, we're now beating a dead horse a little bit, but Betsy, this guy is literally saying that even though this is a murder defendant, she deserved as much fairness as possible. Like, they're citing this interview, but all you have to do is play the interview. Is it a mistake in their filing? I don't know.
I don't know either, but just from a practical point of view, as a regular person, what is the point of interviewing this guy? He's not going to say anything different than what he said on your program. And if he repeats what he said on your program, it defeats their entire motion. So I think, they don't even get there. I don't see Judge Everett even allowing the interviews to go forward. I don't know if, Tim, you feel differently.
Yeah, you have to bring and show a clear abuse or violation before that judge is going to make them come back and discuss what they said. And he told them that you never have to discuss this again. You can talk about it. You never have to discuss this again. And he's not going to do that on a willy-nilly motion, just because this guy you'd love to have a beer with, but I wouldn't put him on my jury. And I'll bet his favorite witness in the trial was the bump man.
Bump? Yeah, that's one of them. Rob was one of them. And who they loved was Chris Corbett. They all love Chris Corbett.
Yeah, he's very professional. Tough witness.
Yeah, look at this. DJ Meow. Betsy is a best guest, but the best boss. Look at this.
That's your employee? That's your employee?
The subordinates are coming in. DJ, we have to get DJ on the show as a guest. Does Donna have the best of the best? Yeah, Tim, what is Donna going to do? This is not an appellate attorney. This is her attorney. But, I mean, can the Adelsons afford 2 Michael Uffermans at this point, or is Donna going to get screwed with some sort of public defender?
No, probably she's not going to get a public defender. She's got funds, and if Michael did it, he'd probably do it on a discount since he's already read the transcripts. He's very familiar with the case. I don't think there's a conflict because Charlie didn't testify. I think he could handle that appeal. So. Yeah, she's going to hire whatever she needs.
And Tim, I know we wouldn't get through the show without a question like this from Ken and Jen and Jen and Ken. T. Jansen, any new thoughts on the remaining Adelsons? There was talk about some sort of grand jury convening. Any word in your neck of the woods? Or just wait and see.
I don't want people to get mad at me. I hate to be the doomsayer, but I don't believe there's any imminent charges going to be filed, any new defendants.
What does imminent mean? Does that mean like it's not happening right now but could happen? Oh, boy.
I think what I'd like to see people do is go look, when you have witnesses you give immunity to, right? And then you have to have a hearing that you can't use any of that information, right? It's called Castigar. Just go back and look at the Castigar cases. You're going to see that you've never really had Castigar hearings since the 70s. And wonder why is that? Because they don't normally prosecute people who they've given immunity to. All right. Just go look at the case law. Now, that Castigar, listen, I've been practicing law for almost 40 years, federal prosecutor defense. I've never seen a Castigar hearing ever in 40 years.
Betsy, let you read between the tea leaves. I mean, Tim knows people. You say nothing imminent. Do you think that the state is putting together something and that it's just a matter of patience required, or is there something regarding the derivative use immunity that's going to make it very difficult to prosecute?
Well, I don't have the same connections that Tim has. I'm just a regular old person, but I keep going back to the timeline preceding the what Stephen said on your program recently about the motion of fraud that was going to be filed. And I keep going back to that in my head because as you look at the timeline, and the deadline for the filing of that motion was on the date of the murder. And I don't think any of that information is derivative of her testimony. It's coming from other sources. So I still think that they're going to arrest her. I mean, send your hate mail to Tim because I still think
all Tim said was imminent. That was the word.
That's right.
He used. Imminent doesn't mean.
I did.
Okay. I
like
originally predicted 1 week, and I'm way beyond that now. But as long as everybody else said 3 to 4 months, so as long as I don't go over, I still win.
But you got the jury verdict right.
I did.
You said no questions and a quick verdict, right?
We are staying.
Thank you,
tuned.
Tim, for mentioning that.
I remember everything you say.
I mean, Georgia said stay tuned twice, so Tim is just saying not imminent. And Tim, what about this here? So for Brianna, who's in the chat always, a witness would have to flip or new evidence uncovered. I mean, is it possible that they're sitting on new evidence from these devices that we just don't know about right now? Is that possible?
There just is so much that, let me just say this. Before a prosecutor gives immunity to a witness, they should fully understand what that encompasses. Because when you force somebody to go on a stand and testify, and you're compelling them to violate their own constitutional right to waive it, and then you want to use it against them, the court is going to go out of their way and protect that person who was forced to give up their constitutional right. That's a very high burden, very big burden. And it's going to get hatred. And there's one crazy guy that's going to go on the internet again. So be it. And I challenge that guy to have his experience that I have in courtrooms, in trials, handling cases. I'm just giving you my opinion. This is a very difficult hurdle for the state.
There you go. I mean, that's reality. But to Betsy's point, I don't, we're going to see how it plays out. I mean, Tim, again, used the word imminent. So like Christmas time is not imminent as it relates to right now, unless, I don't know, you're talking about.
My daughter's wedding is imminent.
Yeah, your daughter's. Yeah,
that's in December.
Analogy. Miriam says, unfortunately, I think like Tim. Tim errs on, like Carm thinks like Tim, erring on the side of paranoia. I don't know. This is a safe space. All opinions are welcome here. Tim is not saying that she's not being indicted ever. He's just saying that right now, imminently, it is not happening. So I just want to underscore that before, because trust me, I'll get the hate mail too. And I'm not reading it tonight because I need a break from the hate mail. By the way, if you appreciate the content, now that we are discussing that, please hit the like button. Please subscribe. Please share with a friend. Next week, Donna will be celebrating the Jewish New Year from jail, and I'll be celebrating it from my home in Miami Beach. And we will try to bring you some content over those days, but that's going to be a little break for the Waldman family for the holidays. Just giving you a little heads up now. Back to now. Now we're talking about Patricia Byrd here. She's one of the jailhouse informants. It says, at this stage, the court must make a finding that Patricia Byrd was credible before considering Miss Adelson's alleged confession to Byrd. Under no set of circumstances can Mrs. Byrd be considered credible. She testified the defense investigator with whom she spoke was a white woman. Ms. Khan was obviously not white. Tim Jansen, I don't know. It's a funny argument. They're saying she's not credible because you couldn't get the race of the woman, the defense investigator's race right. Is that enough reason here to disregard her as a credible witness?
No, the jury instruction says if the witness says or says something that is contrary to what they said before, you decide what credibility, you decide whether you accept all of it, part of it, or none of it. You're the triers of fact. You determine credibility. It's not the court's role to determine credibility. It's the jury. We don't even know if the jury even considered Byrd's testimony credible. So how can he say if you wipe Byrd out, they still might have found her guilty?
By the way, I asked all the jurors about Patricia Byrd, and most of them said they took her with a grain of salt. That's what they said,
right?
Because
of course,
because they're inmates, and they took it with a grain of salt. So, Betsy, to you reading on further here, it says Miss Byrd's testimony should be disregarded completely. The same is true of Drina Bernhardt, the other jailhouse informant. It says Miss Bernhardt's motivation to lie was and is significant. With 27, I'll give him credit there. 27 felony convictions is a pretty good amount. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison releasee reoffender, Bernhardt's credibility was significantly impeached. However, the surveillance video admitted into evidence establishes that she and Miss Adelson worked together to write the script. I mean, again, they're arguing about these two specific witnesses, but we learned from the jurors since that they didn't take them as sort of star witnesses or prime witnesses in their decision making.
Well, the difference between Bernhardt and Byrd is Bernhardt had the receipts. She brought a script, and they played the video showing Donna writing out the script. They had a handwriting expert verify that it was a script, not that they needed one written by Donna. So, you can believe her because the script corroborates what she was saying. With regard to Byrd, you're just trying to having to take her at her word. But again, that's the province of the jury, not the judge, to weigh the evidence that goes to the weight of the evidence. So that's the province of the jury, not the judge. And they're asking the judge just to take the jury out of it with regard to Miss Byrd and say she wasn't credible. So, she wasn't a valid witness in this case.
Yeah, Jackie, go ahead, Tim.
So the defense is complaining about the credibility of these witnesses, but yet they played that long video of her client sitting with the defendant, showing there was opportunity for her to do exactly what the lady said. Now, why would you show that video? Her sitting down with her writings. I don't know if they were thinking when they introduced this evidence. If I'm a juror, I'm like, oh, she said she wrote this script. Oh, look, she's sitting with her in this pod area, not in her pod, not in her bed, but off by themselves. So she had opportunity.
This is funny. I'm just looking at the comments, but I believe the snitches in Rivera and Katie 85%. And it's interesting because some of these jurors said, across the board, people think that Luis Rivera, despite not being a very good person, has always been pretty credible. But let's scroll forward here. This is the actual filing from today that we're kind of going through piece by piece. That had to do with the jailhouse informants. It says here there's no evidence that Mrs. Adelson committed any act. So this is interesting, Tim. There's no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior to it being completed. And for that reason, the evidence is not sufficient to support her convictions as a principal to first-degree murder. I mean, Tim, again, this is what these jurors had to figure out. And Georgia had that amazing metaphor, Sarah Catherine Dugan, of the train car. And these jurors all said it was obvious that she had, a part in this, even though I guess there's no direct, there's no smoking gun. The
Right.
jurors still came to this conclusion.
Well, this is the one that Joe and I agree is their strongest one on appeal. This is their strongest motion for the first-degree murder. And that's why I thought principle in this, no direct evidence before. I thought the jury might have some concerns. And so that's why I thought it might take more than a couple hours for a verdict. But this is their strongest one. We'll see what the jury does, or the appellate court. The appellate court does what they did in Winchester or Denise Williams. They might throw out the first degree and leave it with the conspiracy and solicitation like they did in that case.
Yeah. Jared Ross stepping in here. I think they have a lot of evidence against Wendy that did not come from any of her testimony. You just don't know what you don't know, but I would have to agree optimistically with Jared. I also believe, I mean, this is silly, but I believe in momentum and karma and all these things. But Tim, the defense dropped the lesser charges. Do you think this jury would not convict a grandma? I forgot about that part, Tim. They did drop those lesser charges under murder one, right?
Well, they must have been thinking, okay, if they can't prove the first degree murder, we don't want the jury to make a concession and go with manslaughter or second degree. So we want all or nothing, because if you get, manslaughter, you get second degree, that's still the rest of her life. Let's shoot for you getting out. Let's shoot that they didn't have enough for first degree and we'll find you not guilty. Well, they were wrong.
Look at this comment. Welcome to my life. Joel, I thought you said we're going to get news stories this week, not related to the Adelson family. Crazy for crochet. It is Tuesday. How many days in the week? There's 7 days in the week. We've still got Wednesday, third. Tomorrow is another Adelson. We have some witnesses coming on tomorrow, but Thursday, just for you, Crazy for crochet. And by the way, someone from a foreign land from me, I want to say in like Vienna, emailed me a beautiful email that they started crocheting. And I hope it's not you, Crazy for crochet, because then I would be poking fun at the person who long story short, they started crocheting a blanket at the beginning of Donna's trial, and they finished it, and they wanted to gift it to me, which I'm going to gift to Carm. So they were sending it from overseas, and that's why I say best guess, better community, and also because of this. You notice I am leaning down because our mic stand is broken, and when I was in Tallahassee, someone brought me a Fisher-Price toy because we have Fisher-Price equipment to remind me. That's why I'm low riding in the chair today. Shanta, the defense pisses me off. They conceded that Donna authored the script, not the inmate. What about that, Betsy? That's interesting. Did they just put their foot in their mouth, I guess?
Yeah, they absolutely did concede that. And, when you have witnesses whose credibility is in question, you have to look at what they're saying and does it fit into the rest of the evidence. And I think that definitely is why Katie Magbanaway's testimony never made sense until she started testifying against Charlie and Donna. And then all of a sudden you could find her believable because what she is saying can be corroborated and make sense. And so that's what they did with this particular inmate is, they didn't just put these people on and say, tell us what you know, but they brought the goods with them, something that couldn't be refuted. And so that made at least that one inmate credible.
We'll go through a little bit more of this as much as I can tolerate, and then we'll get some final thoughts in a little bit. But this is we're finding out a motion to nowhere. Let's see here. Charlie's testimony Charlie's testimony also included the fact that he did not tell Mrs. Adelson, aka Mom, he paid Magbanawa for the shooting until September 17th, 2014. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17th, 2014. I mean, Tim, the thing is, we've got, thanks to Chris Corbett, like an hour and 6 or an hour and 8 minutes unaccounted for, where the jurors, again, came to the conclusion that there was some sort of handoff going on here. I mean, you'd literally have to restructure the jury system and the way evidence is presented in court for that. I mean, they're trying to structure the narrative according to their own details.
Did the jurors say that the outside meant outside and 10 minutes meant 10 minutes? Did you ask him that juror?
I did not. But I did ask the juror about that, and they just said something along, I think it was juror number 5. I think it was Mitch McKenzie, who basically said, look, that was very odd. That's what he said. It was very odd. Everything went dark at that time for an hour and 6 minutes. It was the night of the, after the murder, and they were on their way to Tallahassee. So I think they just kind of came to their own conclusion there. Timothy. Well,
did you ask me a question? I'm sorry.
Tim's getting ready for Sunday. No. I was just saying that they all just kind of concluded that time period, that hour and 6 minutes, was something shady was going on. But
certainly, they certainly had that time frame fit within the geo tracking of the phone lines, right? And it fit the text messages between the two co-conspirators. Outside 10 minutes. And it fit the narrative that the co-conspirator Katie said Mom just came by and dropped the money off with Harvey. It all fit. And they don't want it to fit. That's why they came up with that excuse. Outside doesn't mean outside. Same way Charlie had to say that he gave the money only because he was embezzled, because they knew it was stapled, and Lewis got stapled money. So he had to come up with an excuse, right? Had to come up. They knew that she wrote that inmate wouldn't have had that information, and they knew it was her handwriting. So then they just try to diffuse it by saying, oh, she wrote it, but she told her what to say. You just can't. It defies logic and common sense.
By the way, I was looking at some pictures of Robert Redford. May he rest in peace. Passed away at
89.
89. Him and Paul Newman, man. Some good-looking fellows back in the day. Neither with us anymore. The popcorn is still here, though. That's when movie stars were movie stars. No evidence was admitted during trial to establish the purpose for which Mrs. Adelson had the tag number in her 2014 planner. At worst, even if Mrs. Adelson dropped cash off at Charlie's house after the murder, Betsy, and signed the payroll checks after the murder, it would establish her culpability as an accessory after the fact, but are not competent evidence as principal to first-degree murder. Again, I mean, is this in your opinion the strongest part of their filing here?
It seems to contradict the paragraph you just went through, where they said, the only evidence that she knew anything was as of September 14th, and this money drop happened the day of the murder, correct? Because they were on their way up to Tallahassee. So, again, common sense. It does not make sense that somebody who didn't know a murder was going to happen is going to drop money off the day of the murder right after it happens. I mean, of course, if anything, that suggests she did know. She did know. She had the money ready to go. She had even washed it, and she dropped it off. So no, I don't think that has any merit.
So you'll look at these motions, and this is the exact reason why Donna did not testify. It looks like this defense team, their whole defense was to beat murder one. That was their whole defense, was to beat murder one. That's why they never talked about the tag in the planner. They never asked questions. They never did anything. That was there. They didn't want her to have to explain. She would have had to explain that if she took the stand. And they're going back. Everything was done afterwards, nothing beforehand. They're trying to get the same thing that Williams got and get that first-degree murder overturned. That is
Yeah,
what they're trying to do.
but even without first-degree murder, with the other charges, solicitation, conspiracy, it's a life sentence, right? So
Well, she'll get 30 years on count on the conspiracy and 30 years on the solicitation.
when she's 70,
And
gonna be
but
76
they're
years
going to
old.
say we won the first-degree murder count,
Oh, wow.
and they'll claim it was a victory.
Yeah, I mean, I could see that. Tayo Toys here. What happened to Charlie's Ferrari? And he just asked if Wendy's going to hand glide into Mexico. How about a hand glider with Wendy on it? I'll put that right next to my STS Ferrari that I keep sacred in the studio. Let's see what else we've got going here. When does Donna go to prison? Tim, tell us. There's more here. We're going to get to it, but real quick, Tim.
Yeah.
Sentencing, which is now described as a case management
That's
hearing.
not sentencing.
Yeah. So what is that? It's on October 14th. So what's going on here?
What's going to happen is they're going to come in at sentencing or at the case management.
Oh.
Do we have the pre-sentence report? Those things don't get done in 30 days. Sometimes it takes 45, 60 days. They're going to say, does everybody have the pre-sentence report? Yes. Okay, let's set a sentencing date now that everybody has it. Because if you set a sentencing date and you don't have the pre-sentence report, they're just going to have to continue it. After having sentencing, they want the victims to be able to come and call witnesses. And so that's what they're doing. Case management is not sentencing. If the judge was going to do sentence, he would have said sentencing.
So when do you think sentencing will happen?
It'll probably be 30 days after the case management.
And then does she get remanded right after that to state prison? Is that when
Well, she's in custody. They'll keep her local, and then usually 7 days to 10 days they transfer them to the intake for the Department of Corrections, where they'll do her medical, her dental. They'll look at her crime. And then they'll determine where they're going to house her with separatees. Like she can't be with Katie, so then they'll determine where she's going.
I've heard she's probably going to Lowell, which doesn't sound like too much fun, but we did a show on that earlier in the week. Okay, so this is the last part of this filing we'll read, and then we'll get some final thoughts. There was also no evidence Mrs. Adelson was even aware, according to Jeff Lacasse, that's Wendy's ex-boyfriend, that Charlie Adelson looked into hiring a hitman in the summer of 2013 to establish a prima facie case of conspiracy. The state had to admit evidence that A, the intent of Donna Adelson was that the offense of first-degree murder would be committed, and B, in order to carry out the intent, Donna Adelson agreed, conspired, combined, confederated with Charlie Adelson or Catherine McManu or other persons to cause first-degree murder to be committed either by them or one of them or by some other person. Again, Betsy, this is all legalese here, but I guess Tim's point is well taken in that they're trying to basically lose the murder one rap, which is a moot point for Donna because 30 years, 5 years could be the end of her existence on this earth in a prison. But do you agree with Tim that appears to be what they're after here?
Yeah, I do. And I agree with him as well that that's probably, the weakest part of the prosecution's case. I think they did establish through the text message about the birthday gift that, she knew. And one of the jurors even testified, one of the biggest pieces of evidence that convinced him of guilt was the code. And here they are talking in code about a birthday present. And this was before the murder. Right in line to where the first attempt in June 2014 occurred. So to me, that's evidence. Now, is it overwhelming evidence? I don't know, but here we are trying to put all this together, and there was evidence of it, and the jury recognized it for what it was, and that's why they ruled the way they did. But I do agree with Tim that is a little. If I'm troubled by anything, that would be it.
So looking at this now, it appears the way their motion practice, the way they tried their case, kept Donna off there, called these character witnesses, they would never trying to win this case in the courtroom. They're trying to win it on appeal, and they're trying to argue that none of the elements have not been met for first degree and for conspiracy. That's what they're hoping to do, is win it on appeal. and they did all they could or did not do anything that would attack those arguments they're going to make on appeal. They preserved them for a new trial, so they'll have them for appeal.
Tim Jansen, why do you think it is that not one juror, as far as I know, from Charlie Adelson's trial did any media? And by the way, if you're out there and you want to do media, survivingthesurvivor@gmail.com. But why do you think that is, Tim? Why didn't they come forward?
I think they were more, I think that they were older. And I think this jury was more scared of Charlie than they are of Donna. And I think they felt more free to talk about Donna than they were, because I think they had a lot of vitriol for her because they realized she was the one that probably caused this thing to happen. She was the reason. We all know Charlie didn't care. I guess that's a little cavalier. Charlie wasn't concerned about Wendy being up here as much as Donna was, because Charlie really wasn't losing. Charlie and Wendy were never that close, it seems like. And he didn't have time to take care of the grandkids. He was out there trying to make grandkids. So I think just the vile hatred towards Donna and her cavalier attitude and what thought she could get away with this crime, I think these jurors wanted to come out and say how strong the evidence was. And these are younger jurors. Their social media is important to them. It's their everyday life. And so that's why I think you see that now. And I think we'll see it going forward. More jurors, you're going to see the jurors come out on social media.
So this is interesting. I'm glad the COE brought this up. This is important. So Josh Selman, at least once, if not more, and this was when Donna was getting ready to testify, he said that he had hesitations for his client to do that because of, quote unquote, the peanut gallery. And I'm going to read this. And I got to be honest, and I'm being fair to Josh Selman. I have no idea what he's talking about. I wasn't in there for every minute, but I was in there for a lot of the trial. And I did not notice any of this, and I consider myself fairly observant. But point 65 here in the filing, not only he's talking about the gallery, people who were there to trial watch, not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. This interfered with the jurors' ability to focus on the evidence. Not one of them told me this, and distracted them from closing arguments. Not a single one said that to me. The court admonished the defendant on numerous occasions that she was not, meaning Donna was not permitted to show any emotion in the presence of the jury. The law does not require that a defendant appear without any emotion. Betsy, I honestly don't know what he's talking about. It would be wrong if people in the gallery were doing that, and I don't think Judge Everett would allow that. He gave directions. He even walks back to the gallery. People don't see that when he's not on camera. He walks toward the gallery. He stands right at the entrance to the gallery, and he says, "Under no circumstances will you guys make any faces." Yada yada yada. I'm not sure what Josh Selman is talking about here. I mean, it's concerning if it happened. I can't imagine he would just make it up. Would you?
No, but I'm feeling a little gaslighted here because I was there for part of the trial and the rest of it I watched, and I didn't see anything like that. And I remember hearing the judge clearly tell the gallery over and over again, nobody make any faces, nobody react. He was always out in front of that. And not only that, but the judge was there. The judge could have seen, he was right at the front of the courtroom. He could have seen that if it was happening. And if I have no doubt that if it was happening, he would have said something. I mean, there's one thing you can say for Judge Everett is he went to great lengths to make sure that this was a fair trial. And so I don't know, again, to Joe's point before, like it's general. There's not like a lot of this is what happened during this witness at this point in time on this day. There's none of that there. There's just kind of general allegations that the gallery was acting the fool. And I don't remember that. I didn't see that. And I don't agree that that's accurate.
Yeah, by the way, Maureen Guichard here with a comment that's interesting. The defense didn't even know when one of their witnesses was sitting in the gallery. That happened twice
Great
back to
point.
back, back to back days where they were supposed to be sequestered. The only one making faces and acting a fool was Donna. But listen, I will defer to Josh Zellman. Josh, if you want to come on, the platform is yours. We talking about practice here for Tim. This is intense, Tim. Are you saying that the defense, with that funny Canadian spelling, literally withheld certain evidence or just arguments? Does this mean ineffective assistance of counsel arguments are void if they argue this, Tim Jansen?
No, a lot of times you have what's called trial strategy. And as long as your client signs off on it, and we know at one time the defense needed time and they took and the judge had the client sign off on it. And I think it might have been when they were going to admit that it was her handwriting. They wanted her to admit it because it's kind of an admission, and you don't want the trial to get a conviction and then come back and say she never wanted them to do that. I think this was a little disingenuous about her not being able to testify. They didn't even come back in the next day and say, Judge, now she wants to testify. And if the judge would have denied it, they might have preserved it. But at no point did she ever say, I want to testify. At no point. And she had 24 hours after, because they didn't do closings till the next day. And so I think they waived that argument.
All right. I think that's enough of
and I watched the
filing
trial,
there, COE.
Joel, and we didn't see anything from the camera view, and we didn't hear anything. He should be more concerned if the jurors were laughing while he was doing his case. But I will tell you, I've done closings where I've seen jurors nod and I've seen them do the opposite. And, it doesn't mean they can't. When you're making an argument and you see a juror going like that, that doesn't mean they're disqualified. I mean, it's very discomforting when you're making an argument. And then sometimes when you have a closing and you see jurors going like this, you feel really good, right? But that doesn't disqualify them. That's just how people perceive and intake information. Some of them look, and sometimes they're looking like, yeah, you're full of crap, but that doesn't mean anything. There's no way that the court was going to have the people in the jury making mark comments and laughing. The bailiffs were right there. They were on top of people, and they got two bailiffs that all they do is sit and watch. Right.
Yeah. The COE has now inherited through osmosis my OCD. She's insisting on this final point here. The court showed favoritism to the state at almost every junction of the trial. I mean, Betsy, this sounds like, and I love my kids, one of my kids saying that I'm favoring my other child. This literally sounds like a 5-year-old making this argument that the court showed favoritism to the state. If anything, I think Judge Everett went above and beyond because he knows about, the appellate process and what could happen to make sure that Donna Adelson was properly, attended to, I guess.
Yeah, I mean, I get that from my kids a lot too. But I don't agree with that either. I mean, I think Judge Everett, I have a question for Tim before we break.
Sure.
Tim, what is normal for a normal period of time for a defendant to decide whether to testify on her own behalf or not? Because in my view, they're complaining in this motion that she didn't have enough time, but she had 2 years, right? She's had a long time to decide this issue, correct? I mean,
plus, I think he was very lenient with time during the trial, Tim.
He did give her extra time, but at some point a decision has to be made because he also has to efficiently control how the trial is going.
Yeah, and more importantly, he's got to do the jury instructions. But listen, that is one of the most important things in a trial, whether the defendant's going to testify. The judge needs to know. It's a constitutional right that we all have. And so the judge doesn't wait 15 minutes and says, hey, is she going to testify? He was asking for days. He was asking for multiple days. I need you to tell me this. Let me know by noon tomorrow if she's going to testify. And when you're in a trial, you might have not decided if you're going to testify. You wait to see how the evidence goes. Sometimes we make a last second decision not to testify or to testify. But I don't. They had some time to know. They had to know what they were doing. The way they called their witnesses told me that she was never going to testify. And I think they might have had a struggle internally with the lawyers. But the way they called character witnesses first and then tried to attack the Vietnam, that clearly showed me she was not going to testify. And if they wanted to preserve that, they should have came in the next day because they said they wanted more time, right? And it was the end of the day. And then she said no. But what happened the next day? The court would have let him reopen. If she said, Judge, my client's to change their mind, she wants to testify. Judge, it would have been a reversible error if he didn't let her testify. Yeah. So I don't think that's really anything. And a good appellate lawyer for the state will say that. She didn't preserve it. She didn't come back the next day. She had plenty of opportunity. She never asked to testify. Judge didn't deny her. She told the judge she wasn't going to testify. It's over. It's done.
Tim, this Tommy Castellanos is not the quarterback at FSU, but he is a lawyer, I think, in Tallahassee. Judge allowed a lot of leading. Do you agree with that?
I do agree with that. And that happens with trials. Some judges allow it. Some judges object on their own. Others, they wait for the trials. Hey, this is your case. You try it. I'll call balls and strikes. But if you don't object, then the judges, let it go. And they did. And it was a lot of leading. On direct examination. You can lead on cross, but it was a lot.
Lest you think we are not the future, it is the next day in Australia where they are watching STS on a Wednesday, wondering how come we're still doing the Adelsons. We'll pivot to a different story eventually. Betsy Burgess is a defense attorney out of Tallahassee. Her father, you heard, is a Marine, but she says the real badass in the family is her mother, who raised 6 kids. So I think we're gonna have to do a show with Betsy's parents on at some point to get the lowdown. But Betsy, your final thoughts here. I think the jurors did yeoman's work. I think they did exactly what they were supposed to. But I'm just a piddly little podcast host somewhere in Miami. But I talked to them, and they seemed like they took the job really seriously.
Yeah, that's what I heard from each and every one of them. And when Joe said the other day that, she was very impressed with the jury foreperson, I was as well. These are jury people who are regular people. They're not meant to be attorneys. They're not supposed to be, experts in the legal field. They're people who come in and spend their time and try to do the right thing and listen to the evidence. And every interview I heard from one of these jurors reflects that they did that. So I'm proud of them. I'm proud of the community. I'm proud of Judge Everett for keeping the trial here, because we clearly had a fair jury in this case. And it was meant to be held here because this is where the crime happened. It happened to our community. So I agree with you. And I agree with Joe that these arguments having to do with juror misconduct have nowhere to go.
Oh, by the way, we're finally getting into a rhythm. The COE's all over STS. I've got this brand new shirt, but the COE made shirts that say "Stay tuned." Also, a shirt that says "Was it worth it?" which is what Phil Markel said at the end of his victim impact statement. I think you just find it on the YouTube. There's a link to the merch store. And shout out to the chief of everything. That is a COE, Space Coast on the West Coast, Steve Cohen, the best booker in the business. And of course, the mods. We can't do it without the mods. And as I always say, best guests, better community. And of course, the matriarch of the show, Carm, who I was able to convince to come on last night on 10 minutes notice. So shout out to Carm. Look out, Joel. Donna's after STS. We should send her a Stay Tuned shirt. But she forgets you have an army behind you. Thank you. Look at this name too, Felis Pisaris. But interesting name, and I appreciate that comment. Tim Jansen, as always, you are the famed Tallahassee criminal defense attorney. 1 minute, you had months till the wedding, Tim. Now your daughter's wedding is just 3 months away. It's almost October. Are you getting nervous? Are you trying to pile up clients to pay for this wedding?
I am nervous. And I am nervous. But you want it to be the perfect day for your child and for the family and for their future. It's a new birth. It's a new family you're adding to them. And you're hoping she finds a happiness and long life that, we all aspire to. And so we are excited. And I finally get a son. I got 2 girls, and the only sons I got four legs. So I'm going to get an actual son. So
there you go. And by the way, your Gators are coming down to Miami this weekend.
Please, they're going to lose again. I hope they lose big because we have to get rid of this. I call him Sling Blade. That's his nickname. Remember, you ever watch that movie, Sling Blade?
Yeah.
That's what he looks like. And he's just not the answer. He wants to call the plays, and they're terrible.
What's his name? What's his name? I'm blanking on his name. It's a crazy actor. Yeah, Billy Bob Thornton. Billy Bob Thornton.
Billy Bob Thornton. He's great in Lawman.
Yeah. My daughters, now that, well, I found out that in-state tuition's $8,000 a year in Florida. So then I told my daughters that Tim Jansen went to Florida, and it's the greatest school in the world. And they are convinced that it is. So now, Tim, I want to take them to see the game, but it's like these prices are insane. Like nosebleed seat
down there in Miami.
Nosebleed seats are like starting at $400 or $500 for the like last row in the stadium. Yeah,
Miami couldn't even fill a stadium.
Well, they can now because your Gators are coming to town. We'll discuss this offline. Before Betsy's like, "Am I really listening to this?" But Betsy, what you're like?
Can't they both lose?
Wait, no, but I don't want to say the wrong name.
That's exactly right.
Are you Auburn? Are you Auburn?
I'm Auburn and FSU.
Okay, there we go. I just didn't want to say like Alabama and be wrong, so that's why I let you answer that question. So yeah, I would never do that.
My heart almost just stopped when you said that.
That's why I didn't say.
I'll tell my Alabama people though.
Yeah. Love you all. Thank you for being here. Love you, America. Tomorrow we've got witnesses in the trial and other people coming on to talk a little more, Don. And then Thursday, I promise we'll try to pivot away and discuss other things going on in the world. By the way, not to be political in any way, but I just thought it was interesting. I heard that Greg Skordas, who is a best guest, a very frequent best guest on this show out of Utah, is defending the shooter in the Charlie Kirk case. So what a small world that one of our best guests, Greg Skordas, that's what I heard. I have not even had the time to look at it, but a very small world indeed. So maybe at some point we'll talk to Greg about that. What a job that is. On that note, love you, America. See you tomorrow. And thanks to everybody out there.